Hey everybody, this is Mr. Mob coming at you. Today we're taking a look at topic 2.9 for AP US Government, focusing in on the legitimacy of the judicial branch. So this is taking a look at some of the philosophical foundation for how our federal court system operates and going into a deep dive in terms of the impact of the first real significant Chief Justice, John Marshall, and then the current makeup of the U.S. Supreme Court. So with that being said, let's start off by taking a look at the tradition that kind of defines American law. Now, American law is not created out of nowhere. It is really the result of the evolution of colonial legal practices, which really are taken from British legal practices, which creates what we call the common law tradition. Now, common law means that the law is to be applied to everybody equally, regardless of nobility, being impoverished, etc. Now, that's back in Britain, but the general gist of it is, doesn't matter how rich you are, doesn't matter how poor you are, the basic idea is that the law is applied to everybody. Now, how is this law to be applied? Well, there isn't some single specific, document that says that you must apply the law this way if you are a court, even a major court like the U.S. Supreme Court. Taking a page from British legal tradition, the basic gist of how our court system works is predicated on the use of what we call precedent and stare decisis. And what this is talking about is that when there is a case focusing on a specific issue, the first thing that the court will look at is how has this court ruled on this same issue or a related issue previously. That is the primary basis for how the court is going to rule. Now, that being said, just because there's been a precedent case on a particular issue, it does not mean that it is set in stone. Things change. Viewpoints change. Technology changes. If there is something new that can be brought to the court's attention, that could affect how a precedent case is viewed moving forward. And one of the really important examples of this is on the issue of segregation. Going back to 1896, many of you are familiar with the infamous Plessy versus Ferguson case, which stipulated that public segregation, was not a violation of the 14th Amendment Equal Protection Clause, assuming that the segregation is predicated on equal facilities, hence the term separate but equal. Now, that being said, pretty much anybody that knew the reality of what the Jim Crow South was all about knew that these separated facilities based on race were clearly not equal, but the court really wasn't interested on that. They just kind of looked at it on a very surface level to make its ruling. Fast forward almost 60 years to 1954 in the case of Brown versus Board of Education. Now, this particular case, as we'll talk later on, is focusing in on the ability of minority students to access public education the same with white students. Now, in this particular lawsuit, we already had the Preston case of Plessy versus Ferguson, so the idea being is what could maybe be argued that could maybe affect the court's opinion that could maybe overturn this precedent. You can't restate the same legal arguments because the court's already ruled based on those same legal arguments. So you got to come up with something different. In the case of Brown versus Board of Education, you have Thurgood Marshall who's going to be arguing the case on behalf of the NAACP. And one of the key things that Marshall brings to this case is the famous doll test, which is going to be able to prove that children of color that as young as 5 and 6 years of age, knowing that they are going to segregated schools, have already understood that society viewed them as inferior. So the idea being is that this inferiority, this sense of being less than, is not something natural. It is something that is the result of government action, meaning the public school system acting as a government agent is causing this inequity. And this inequity under the law is a violation of the 14th Amendment Equal Protection Clause. And so that's an example of how you can bring in a new legal argument to have a chance at overturning a precedent case. Probably the most likely major case or major precedent case that could be overturned is, of course, Roe versus Wade, focusing in on the legalization of abortion. Now, that case was heard originally in 1973, but in the nearly 50 years since that ruling, there's been a lot of new technology that can kind of give more of a sense in terms of, when does a human being kind of have its own independent identity from a mother. For example, the ability to detect when a heartbeat starts, for example. So many legal scholars kind of look at the fact that there's been a lot of new technology that's emerged in the last 50 years that might serve as credence to the idea that a fetus has certain rights independent of a mother during a pregnancy, and that might serve as an argument to overturn that precedent case of Roe versus Wade. So we'll see. There's a Mississippi case right now that the court is planning on hearing this year, and we'll see if that has an impact. Now, that being said, the common law tradition is going to play a role in kind of setting the foundational way for how the court is supposed to work, but that's not the only thing that's going to have a major impact or a major influence on how the court operates. A lot of it is also going to be the result of this man right here, John Marshall. Now, John Marshall is not the first Chief Justice of the U.S. Supreme Court. That's going to be John Jay. But John Marshall, without a doubt, is going to be the most impactful Chief Justice of the U.S. Supreme Court at a very critical stage. He's going to be Chief Justice during the early part of the 19th century. Whoops, let me go here. During the early part of the 19th century, where there's still a lot of question in terms of, yes, we have a new Constitution. Yes, there's much more federal power than what we had under the Articles. Yes, there's a supremacy clause. But what do these things mean? How far does federal power actually go? You still have this debate in America, especially with Jeffersonians. And in fact, Thomas Jefferson was the cousin of John Marshall. And fun fact, the two did not like each other personally at all. Anyhow, that being said, there's a question from many of the Jeffersonian Democratic Republicans in the sense of, what about states' rights? How far can states' rights extend? Where do we draw that line between federal authority and state authority? It's going to be John Marshall that's going to be laying down really in a very, very, very strong way what that line is. And that line is clearly going to be with regards to federal power. In the cases of McCulloch versus Maryland and Gibbons versus Ogden, these are going to be cases that are going to be setting the tone that the federal government is supreme. It gives a kind of a broader definition of what the Supremacy Clause means under Article 6 of the U.S. Constitution. In the case of McCulloch versus Maryland, basically the idea that a state government like Maryland cannot legally or cannot constitutionally tax an agent of the federal government, meaning the Bank of the United States, because the power to tax, the power to destroy. You've heard that before. Gibbons versus Ogden, which is a case focusing in on the ability of having a monopoly across the Hudson River. Is it New York's monopoly? Is it New Jersey's monopoly? Who gets to make rules over this, traffic? Well, Marshall, leading the court, says, no, it's actually the federal government's authority because you're actually trafficking across state lines. So one of the big impacts is that Marshall is going to be leading the court in a way that is going to be asserting federal authority. But note, this is not John Marshall singularly just making these rulings. He's the leader of the court, but he's not the only person on the court. And what's interesting about Marshall is that he's the first Chief Justice that doesn't kind of let every justice kind of do their own thing. He is one of a group of justices, but he does believe that the court, if at all possible, has a responsibility to try to speak with a singular voice. The more that the court can speak with a united singular voice, the more credence it gives to what they rule. If you have a court that is consistently divided, especially, by, say, a 5-4 margin, rulings on major cases don't seem to hold as much weight as if it's a unanimous or a nearly unanimous ruling. The more divided a ruling is, there's a lot more credence that, well, the losing side really has a lot of merit to it. So Marshall realizes this, and so whenever possible, he tries to build consensus. Marshall is going to be trying to hold conferences with individual members of the court to try to send the message that let's speak as one voice, let's speak as an institution, not as a group of individuals, thereby making our rulings much more significant. But of all of these kind of landmark things that Marshall's going to be associated with, the most important of which is going to be the case of Marbury versus Madison. Marbury versus Madison is going to be one of our foundational court cases that we have to know. We got to know the background of the case, and we got to know, the constitutional issue, who won, why, and the lasting effects. Of course, the lasting effect is that this is going to assert the Supreme Court's ability to engage in judicial review. Now, this is kind of hinted at, this is kind of implied from Hamilton and Federalist 78, but in this specific court ruling, Marshall says that the court does have the ability to explicitly find actions of Congress and the executive branch potentially unconstitutional. And that's going to be probably the most significant check that the court has on the other two branches. So when we think about the legacy of John Marshall, the idea of having the court speaking as a singular voice to try to give its rulings credence, the idea of asserting this major power of judicial review, and interpreting the Constitution at a very early stage in a way that is asserting federal authority much more broadly than state authority, this is setting a major tone for what our court is going to be looking like and what the powers are really under the Constitution. So, yes, there have been other important justices in the history of the court. No question about it. But John Marshall, no question about it. John Marshall, the most significant of them all, for sure. Okay? Well, then we're going to leave it here for part 1, focusing in on the legitimacy of the judicial branch. When we come back, we'll take a look at part 2. We'll take a look at the current makeup of the U.S. Supreme Court, and we'll take a look at some of the considerations regarding that. Okay? Until next time, we'll see you later. Bye-bye.